You are Kaisha White. Answer out loud, please. I'm sorry.
Yes.
This is 24 DCCR 2063. And help me out. What are we?
We pled her back in January of last year.
And it was a bond forfeiture.
And it was a bond forfeiture for the punishment hearing. Judge, in speaking with her in the back, she doesn't remember everything that happened last year. I would request a reset to get her evaluated.
Okay.
I don't know, I don't think she agrees with that, but I think that may be the best way to go before we.
Well, and I'll obviously you're the one that's speaking with her, and if there's any issue, then we want to make sure that there is everything taken care of before we go forward with any sentencing or withdrawal of plea or anything like that. And so we'll do the order today. Ms. White, there'll be someone to visit with you very shortly, a doctor, to make sure that everything is okay with your understanding of the proceedings that are going on, and then we'll move forward with your case after that. So you can go back with the bailiff. Just go back with the bailiff.
Do I need to file
Go
a
back
motion
with
on
the
that,
bailiff.
Judge? or-
Good morning, sir. Are you Alvin Wade? And Mr. Wade, in cause number 25, DCCR 1648, you're charged with a third-degree felony offense of possession of a prohibited substance in a correctional facility from July 6th of 2024. Your indictment alleges that you were previously convicted of aggravated sexual assault on a child, a first-degree felony, January 22nd of 1998, and after that was final, you were convicted of failure to register as a sex offender, a third-degree felony, November 26th of 2018. What that means is that if you go to trial and you're found guilty in this case, and if those prior convictions are true, the range of punishment would be that of a habitual offender, which is a minimum of 25 years in prison, up to 99 years or life. Do you understand the possible range of punishment if you're found guilty at trial?
Yes, ma'am.
And I have here on the tablet a plea bargain rejection that has your signature with Mr. Rojas's and shows that the district attorney's office has made an offer, if you would like to enter a plea of guilty, for a 15-year term in prison. So that would be to go on counts 1 and 2 only. You have every right to reject that, have your case set for trial. I just want to make sure you understand what the possible consequences are and what your options are. Do you understand all of that?
What counts 1 and 2?
So counts 1 and 2, that just makes it a second-degree felony instead of the habitual. So it's the offense you're charged with and one of your priors instead of both of your priors.
Oh.
So that's how we get to 15 instead of that minimum of 25.
Oh.
Make sense? And so do you want to reject that offer and have your case set for trial?
Yes, ma'am.
All right, we'll get your case set for trial, Mr. Wade.
And, excuse me, can I say?
Uh-huh.
I want to invoke my Sixth Amendment constitutional right
To,
speedy trial.
you're lucky because in this court, we only have 50 cases waiting on trial. So every case is getting a speedy trial now. So you will get set for trial as quickly as possible, and we'll get your case taken care of within a very short amount of time. Now, I wanted to ask you, Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release Mr. Rojas. I can appoint another attorney who could begin preparation for trial probably a little quicker. Is that okay with you?
Will I have the same right to gather the evidence?
Yeah, of course. Your attorney will get all of the discovery. They'll go over all of that with you, and then we'll get your case set for trial.
And like pictures, I need him to take some pictures.
Just listen. Let's start with, do you want a different attorney so they can prepare quicker, or do you want to keep Mr. Rojas?
If you're gonna,
Any attorney,
he told me he was a cop out lawyer.
I can't imagine that Mr. Rojas
Yeah, he
used
said-
those
he said
words.
it's on the kiosk. Yeah,
I said she'll give you a new lawyer if you want to. It's just somebody that can get ready faster than you.
you say you're a cop out lawyer that's make deals with the DA. I need a lawyer that's gonna help me.
Any of the attorneys who I can appoint in my court are going to represent you to the best of their ability.
Your Honor, if I may, Mr. Rojas has negotiated with me back and forth on this case. We discussed this case at length, both the strengths and the weaknesses in the state's case. just for the record.
I have no doubt that Mr. Rojas has done an excellent job already. But Mr. Wade, I just need to know
Okay.
if I have your permission to release Mr. Rojas and appoint someone else, or do you want to keep Mr. Rojas? Is
Well,
that
I'm
something?
gonna take your advice.
It's not advice.
Oh.
Don't be putting words in all of our mouths. I'm not giving you
said he
advice.
was a good lawyer, huh?
I'm saying everyone on this list is a good lawyer. So you can keep Mr. Rojas, or you can get someone else off of the rotation who could probably start your preparing for your trial a little quicker. Mr. Rojas
Okay.
just handles a lot of cases for me.
Okay. Then I need a lawyer that, gonna handle my case as
Quicker, because you're asking for a speedy trial and all. Perfect. So I'm going to release Mr. Rojas. I will appoint someone today. They should be out to see you very soon to begin preparation for trial.
Yes.
You can go back with
Yes,
the
sir.
bailiff. And good morning, Ms. Burge. Would you please raise your right hand? Do you swear or affirm that you will truthfully and accurately translate from English to Spanish and Spanish to English?
Yes, Judge.
Thank you. Sir, are you Christian Lazo?
Yes.
And Mr. Lazo is charged with aggravated robbery in cause number 25 DCCR 1423, and that's from May 25th of 2025. And Mr. Lewis, it's my understanding that you need a reset to meet further with the Assistant District Attorney and work on the case. Is that correct?
That's correct, Judge. We've met with Mr. Lonzo with Ms. Burge to go over the situation with him. There's definitely some additional investigation that needs to happen before we move forward.
Okay. Any issue with that, Mr. Nichols?
No, Your Honor.
Mr. Lazo, I'm going to reset your case so that you can meet with your attorney and then some more and discuss, and then we'll be back at a later date to get an announcement in your case.
Okay.
Thank you. Thank you, Ms. Burge. You can go back with the bailiff.
Thank you.
Sorry you had to wait. I'm so sorry. Are you
Right,
Camden
so,
Jackson? And this is 24 DCCR 0114. Mr. Jackson has recently been, or more recently, been evaluated for competency to stand trial by Dr. Krapon. I've received that report and going to take judicial notice of the court's file. The report from Dr. Krapon is dated December 4th of 2025. He makes the finding in that report that Mr. Jackson is competent to stand trial. Is there any other evidence with regard to competency?
Just not to competency, but there is a concern that I've come to find out, of course, that the entire time Mr. Jackson has been in custody, he has not been on his medication and not been given his medication, and considering some of the medication he's on, I think it explains a lot with the acting out and things, the issues you've been getting from jail.
Right.
So that's a big concern of mine, if we get him medicated and dialed in, so
Okay.
try to move forward.
So what I'm going to do then is make any other evidence with regard to competency.
No, not with regard to competency, Judge. I have reached out to that jailer. I know it was earlier due to the proximity of this violation to his actually being granted probation and his behavior in the jail. I did reach out to her. I think she works a different shift than all of us do. I think she's there all night, so I've had a hard time doing that, but I'm happy if the court needs to speak with her. I don't know that we have proceeded on that count one way or another yet.
Well, no, we haven't done anything because we've been doing competency evaluations. And so here's what I'm going to do. I am going to make the finding based on that report that Mr. Jackson is competent. If you'll make a notation and put it on my desk, I'll contact the jail to find out what they need as far as having him evaluated through their medical staff for any medication. And then we'll see if that will help. And then we'll reset it.
And also, Judge, I don't know what kind of help you can provide in this regard, but some of the issues that he has had at the jail with the fighting or things of that nature, or where he may have initially been defending himself and aggressor or things of that nature, but it's a situation where he has asked to be isolated or move away from certain people, and that they've never done it. And so
There's only so many places for
I
all of them is the problem, but I will talk to the jail about that
Right,
also.
but I understand the biggest issue with him, of course, is the medication.
Okay, I'll work on both of those things after docket. You
Thank
can
you.
go back with the bailiff. Dakota Kuhn, good morning, are you Royal Gonzalez?
All right.
I'm sorry?
Yes.
Okay. This is 25 DCCR 0226. Mr. Gonzalez is charged with burglary of a building. And I'm going to take judicial notice of the court's file. Mr. Gonzalez was previously found not competent to stand trial, was sent to a facility for competency restoration. I have received a report from the John Dunn Behavioral Science Center dated December 23rd of 2025 with the finding that Mr. Gonzalez is now currently competent to stand trial. Included in that is the report of competency prepared by Dr. Cassandra Hayes. And she also makes the finding that Mr. Gonzalez is currently now competent to stand trial. Let's see. In addition, I received from Dr. Madeline Gabe, a letter indicating medications and treatment that also took place. Her finding and opinion is also that Mr. Gonzalez is now competent to stand trial. Is there any other evidence with regard to competency?
No, Judge, nothing.
Not from the state judge.
And so I will at this time, based on that information and those reports, find that Mr. Gonzalez is now competent to stand trial. What is the announcement?
Judge, I received a report, of course, during the holidays a couple weeks ago. I did go out and visit with Mr. Gonzalez to find that our communication was definitely a lot better than previously. I do need a little additional time. I've talked with the state about whether there's going to be any new offers or anything, which he did convey an offer to me that I need to really sit down with Mr. Gonzalez.
Take some time. Let's just do a normal reset, Mr. Gonzalez. Mr. Lewis will be out there to see you again to go over everything, and then we'll find out what we're going to do with your case at the next court date. Okay, you can go back with the bailiff. Good morning, are you Michael Murillo?
Yes, ma'am.
And Mr. Murillo has 6 cases, cause numbers 25 DCCR 0377, charged with fraudulent use or possession of a credit or debit card, 25 DCCR 0378, burglary of a building, 25 DCCR 1078, burglary of a building, 25 DCCR 1079, burglary of a building, 25 DCCR 1516, burglary of a building, and 25 DCCR 1517, possession of a controlled substance. Mr. Lewis, what is the announcement?
Judge, this defendant here was one that I don't remember he was on bond, but he entered a rehab facility and then turned himself in once he was released from there. Recently, we completed a program. I did reach out to Mr. Hoffmeyer about this, trying to get a resolution, see if we can come to some type of resolution. Mr. Nichols did give me an offer this morning in regards to that, and I talked to Mr. Murillo about it. We wanted to at least have the opportunity to go over some of that stuff in the facility and other things that he did while on bond with Mr. Hoffmeyer.
All right, so Mr. Murillo, I'm going to reset your case, just a normal reset, to give Mr. Lewis time to get all that information, get it to the Assistant District Attorney, and we'll get an announcement at the next court date. You can go back with the bailiff. All right, so are you Dakota Kuhn? And this is 23 DCCR 0968. Mr. Kuhn has a motion to revoke his probation, on probation for attempt to commit assault a family member by impeding breath or circulation. One of the a couple of the allegations have to do in that motion to revoke with the possession of controlled substance out of Chambers County.
Right.
Mr. Lewis has informed me that they have at this point filed those charges and have them over there, and it's asking for a little bit of time to get with them, get all of that information so we can go forward. So I'm going to reset your case, give him a little bit of time to get everything figured out that he can, get with the district attorney, and then we'll figure out what we're going to do at the next court date. All right, you can go back to the bailiff. Good morning, are you Mike with that? We can have Dr. Holmes try. All right, are you D'Antonio Riggs? And Mr. Riggs is charged with aggravated robbery and cause number 25 DCCR 0975. We had Mr. Riggs evaluated for competency to stand trial. I'm going to take judicial notice of the court's file. It includes the report from Dr. Grapon, which is dated October of 2025. And I'm not sure if I haven't already made this finding. I feel like I would have had a court date since then, but it is and does have the finding in it that Mr. Riggs is competent to stand trial. Is there any other evidence with regard to competency?
Judge, just that I still have some concerns in regards to that matter, especially after speaking with his family on multiple occasions about their interactions with him. When I talked with him, it definitely gives me concerns about moving forward with how we proceed with this matter. I know he's been evaluated before. I would like for someone else to take a look, if that's possible.
Okay. So if you're still having trouble communicating and understanding.
Thanks for watching this courtroom breakdown. Cases like this remind us that probation isn't simply another sentence. It's an opportunity that comes with serious responsibilities. Once those conditions are repeatedly ignored, the consequences can be life-changing. If you found this case interesting, please hit the like button, subscribe to the channel, and turn on notifications so you never miss future courtroom hearings and legal analysis. I'd also love to hear your opinion in the comments. Do you think the 6-year sentence was justified, or would you have given him one final chance? And before you go, check out another courtroom case on the channel where a judge faces an even tougher sentencing decision. Thanks for watching, and I'll see you in the next video.